And now I'd like to hand the call over to Frank Liz. Over to you, Frank.
Thank you. Good afternoon, everybody, and thanks very much for joining our webinar. This is the first in a series of three that we're going to be doing. Our topic today is amnesty and leniency in the United States and in Europe, the process for securing it, what it means in each of the jurisdictions, and some strategic issues that arise in that process. We will have another session that has not yet been precisely scheduled sometime in April to talk about the process for responding to search warrants and dawn raids and all of the issues associated with that. And then in May, we will have a final session on the actual conduct of cartel investigations on both sides in terms of dealing with the agencies on the substance of the investigation and resolution strategies for cartel investigations. So to get started, I'm going to kick it off with a discussion of leniency and amnesty issues in the United States. And then I'll turn it over to my colleague Niels Ersbol in Brussels to talk about Europe. And then we'll come together a little bit at the very end to talk about some multi-jurisdictional considerations and issues that tend to arise in these cases. So in the United States, the U.S. Department of Justice antitrust jurisdiction has the exclusive responsibility at the federal level for enforcement of criminal antitrust violations. The Federal Trade Commission, which many of you may be familiar with, does not get involved in criminal matters and criminal prosecutions. The only types of conduct that tend to be prosecuted criminally in the United States are what we consider to be hardcore violations, meaning price fixing, bid rigging, or express market or customer allocations at a horizontal level between competitors where there is typically no legitimate business reason for the companies to be working together and talking about the relevant issue. Things that are more related to distribution issues, vertical customer supplier issues are not really in the criminal realm in the United States. Criminal violations have very serious consequences in the U.S. At the company level, fines are very significant. The statutory maximum is $100 million per violation, but even that is not a hard limit. There's an alternative provision that's referred to as the double the gain or loss provision, which enables the government to bypass the statutory limit of $100 million and seek an amount that is double the harm inflicted by the conspiracy or the gain to the conspirators. And the government's, although this has not been tested in litigation, the government's position at least is that double the gain or loss provision applies to the conspiracy as a whole and is not limited to the gain or the harm relating to one particular defendant's sales. So if you were to take a conspiracy-wide view of the harm or the gain and then double it, the numbers can get very big very quickly. And for that reason, we do see fines very substantially in excess of $100 million. The two largest in history have both been $500 million. One for Roche in 1999 relating to the vitamins cartel, which was a plea agreement to settle, to resolve the matter for $500 million, and one very recently for AU Optronics that was actually the result of a trial conviction and a judicially imposed sentence of $500 million. At the individual level, there are very significant potential prison sentences, averaging these days about 24 months, theoretical maximum of 10 years, although I don't think anyone envisions it getting that high for antitrust-related offenses only. There's also the prospect of fines. So some quick statistics for folks to see. Before 1994, the largest corporate fine ever imposed for a Sherman Act violation was $6 million. Since then, there have been approximately 100 fines of $10 million or more and 21 fines of $100 million or more. And what you'll see on the left is a chart that shows you over the last 10 fiscal years the aggregate amount of the fines totaling somewhere around $6 billion. And you'll see on the right of the chart a ramp up in the average incarceration period for antitrust offenses. What we're here to talk about today is the DOJ's leniency program. And that program really is the centerpiece of the DOJ's criminal enforcement effort in the antitrust area. There has been a corporate leniency program in existence in the U.S. since 1978, but it did not really become an effective tool until it underwent some significant revisions in 1993. Under the older program, the division received an average of one application per year. Today, the application rate is roughly 2 per month. Roughly 90% of the fines that have been achieved by the government since 1996 are traced to investigations that have been advanced by a leniency applicant. And roughly half of the current investigations that the DOJ has are related to a leniency applicant. And so that distinction between the 90% and the 50%, I think, is significant because it shows you that the largest, most high-profile, most volume-intense matters really do tend to be driven in large part by the leniency program. Various and numerous other jurisdictions globally have adopted leniency programs based on the success of the U.S. program in generating enforceable prosecutions. They're not all paralleled. They're not all the same in terms of the mechanics, but the concept of leniency for the first to report is spreading globally at a rapid rate. The destabilizing effect of the cartels, the destabilizing effect of the amnesty program on cartels is the key driver. And that has been a tremendously successful component of the program. In terms of the benefits, in terms of the ground rules for the program, what you can get is full criminal leniency for both the company that cooperates as well as present and former employees. What you need to do is be the first company to report in a particular conspiracy. If you are not the first to report, then amnesty is not available. There is the ability to receive substantial cooperation discounts for subsequent cooperation in the United States, and the order of your cooperation in terms of the lineup of the conspirators does matter. But beyond position number one, it's a question of a discount off of the eventual plea agreement fine. only the first in qualifies for the full leniency. Beyond being the first to report, the most significant requirement is full and complete cooperation with respect to the violation. That includes both bringing in knowledgeable people in the form of witness interviews and attorney proffers relating to the conduct, and also a comprehensive search for documents that would tend to prove the violation, both with respect to documents located in the U.S. and typically the voluntary production of foreign-based materials that may even be outside of the technical subpoena power of the U.S. If you want to make the cooperation showing necessary to receive leniency, very often you need to bring those in on a voluntary basis. The restitution requirement tends to not be a major factor in the ultimate negotiation with the government over the receipt of leniency, for the reason that there is almost inevitably going to be civil damage litigation in the United States in terms of class actions and individual large opt-out suits in any market where there are criminal investigations that are publicized, and certainly guilty pleas. And the government's position has been that the fact that you are going to be involved in and presumably pay a significant amount to resolve those civil litigations is a proxy for the restitution requirement. The final requirement is that you not be the ringleader of the conspiracy, but typically that is something that is very narrowly confined to situations where a particular company has a unique and central role that's very different from the other firms in terms of organizing and implementing the conspiracy. In that situation, the government would be hesitant to grant leniency, but it does not preclude one of a group of conspirators from coming in, and there is no market share limitation. So you can be the market share leader. You can have been integrally involved from day one in forming the conspiracy with others, and the government is very happy to hear from you with respect to leniency. Amnesty is automatic if you meet these conditions in a situation where the government does not already have a pre-existing investigation into the relevant market. That's referred to as a Type A leniency. Type B leniency is more discretionary, and that applies in a situation where the government is already investigating the relevant market, may well have issued subpoenas. You may have received a subpoena, and based on an internal investigation, you realize there's some conduct, and you decide to pursue the leniency route. In that case, the government will consider how far along its investigation was, the fairness of providing leniency in that circumstance, and your ability to materially advance the investigation from the status quo. So there's a more discretionary component to it, but certainly there is no hard and fast rule that leniency is not available once an investigation has commenced. And in fact, we've been involved in many situations where a subpoena recipient has ultimately been the leniency recipient. As a matter of process, once you decide that you may be interested in exploring the possibility of leniency, counsel can make a no names or a blind call to the DOJ and receive confirmation as to whether leniency is or is not available. They will answer that question on basically a market-by-market basis without you identifying the nature of the name of your client, so that if it turns out that leniency is not available, you don't have to go any further and make any disclosures. If leniency is in fact available for a very short time period, a matter of days, you can secure as counsel a no-names anonymous marker, simply to give you time to make an initial series of consultations with your client and perfect the marker application. But to perfect what is referred to as a marker, which holds your place in line and holds the amnesty position available, you need to proffer to the government the identity of your client and report that there's at least reason to believe, with respect to the relevant market, that your client may have engaged in unlawful criminal activity. At that point, you can describe the conduct very generically, but you need at least to identify at a minimum the market and the client. That marker then secures your place in line and holds the leniency slot open for you to go and do further investigation. Typically, it starts out with a period of 30 days, but that's negotiable, it's extendable. And at the end of that period, you then need to come back to the government with the results of your preliminary investigation to perfect the marker into actually a conditional grant of leniency. If your investigation concludes that there is no evidence of a violation, then basically you withdraw the marker. You would remain subject then to future prosecution, and the leniency slot would become available to a subsequent cooperator. And that certainly has happened, that folks get a marker and then they decide after further investigation there's just not enough to proceed, and the marker is withdrawn. If you do find the evidence, at that point you need to make an affirmative presentation to the government that essentially admits to the criminal violation on behalf of your client, expresses a willingness to cooperate with the leniency process to move forward. So there is a tightening of the standard from the marker stage to the actual leniency stage, where in the marker stage it can be much more conditional, that we believe there may be reason to think it, we're going to investigate it further. To receive the leniency, you've got to come through with the results of that investigation. And what you cannot do, and folks sometimes ask and try to push the envelope on this, is you can't say to the government, we've done an investigation, we really don't think we've done anything wrong, or we don't think that what we did amounts to a criminal violation, but on the other hand, give us leniency. And if you disagree that we violated the law, then we've got the leniency, and essentially play it both ways. Folks tried that in years past, and more recently, the government has come out with some very explicit guidance statements that you simply can't have it both ways, and that unless you are prepared to unequivocally admit to the unlawful criminal conduct, you're not eligible for the leniency. Once you receive the leniency, you would receive what's known as a conditional leniency letter, which then takes you through the conduct of the government's investigation. It provides you with a guarantee of non-prosecution, which runs both to the company as well as to individuals, both current employees and typically former employees, so long as they are willing to participate as requested in the cooperative process with the government. In addition to the witnesses, the cooperation typically includes document production requirements, and so long as you continue to cooperate, the government's non-prosecution covenants are legally binding. There is the ability of the government to seek to rescind those covenants if they determine that the cooperation for some reason has ceased or there's been a lack of truthfulness on the part of the company. Once the investigation is concluded, typically meaning that any criminal prosecutions that result from your leniency cooperation have run their course, at that point, the conditional leniency is formalized in a final leniency letter, meaning that essentially the government has concluded its investigation and you have a firm covenant of non-prosecution. But for the operative part of the investigation, when you are cooperating, you have to be aware that there is an ability of the government to seek to reopen the grant of leniency if your cooperation does not continue. A very significant addendum to the leniency program is what is referred to in the U.S. as Amnesty Plus. Very often you will have a firm that's involved in multiple product markets. And in a particular product market, it is too late for leniency because some other firm is in. And so you're in a position then of deciding whether you want to enter into a cooperative posture with the government for the purpose of eventually entering into a plea agreement, or whether you want to defend and resist the investigation. But the point is that leniency is not available. In that circumstance, if you were to investigate and discover that you had additional problematic conduct with respect to a market that the government is not yet investigating, that's where Amnesty Plus comes in. If you can come into the government and provide them with first to report evidence on a second market, you can qualify under the typical requirements for leniency in the second product, but in addition to that, you get an enhanced cooperation benefit, a discount, with respect to your ultimate resolution of the first market. You still don't have leniency there, you still might have to take a plea, but you do get a better deal, a cooperation discount, by virtue of your amnesty proffer in the second market. So you get a double benefit. That incentive to report conduct in adjacent markets or markets where even though the products may be very different, markets where your individuals who might have had a tendency to conspire on one product may well have a tendency to meet with competitors and conspire on another product, has led to a domino effect, particularly in various DOJ investigations, the most notable being the current auto parts investigation, where initial investigations in Market A led to the necessity of some firms to plead with respect to Market A, but in trying to negotiate the most favorable disposition, they offered up additional product markets in which they received leniency. Those additional markets in turn led to other defendants who had yet additional products, and it's been referred to by Scott Hammond of the DOJ as a cartel tree that's resulted from these auto parts prosecutions. I tend to think of it more as a domino effect, where just one leads to the other. But that is a very, very significant dynamic in what is happening these days at the Department of Justice. To sum up, there's a series of calculations and considerations in deciding whether you are interested in the amnesty leniency route in the United States. The benefits are very substantial if you get it. The first is no criminal prosecution. You're avoiding the significant fines for the company. You're avoiding the human damage and the press of potential individual plea agreements and incarcerations and jail sentences for your entire organization. In addition, there is a provision that enables you, if you receive the leniency, to potentially, and I say potentially because it's not always something you would want to do, it's a very circumstance-specific calculus, but there's at least the potential to try to lower your theoretical civil damages exposure by invoking a provision of Ac Para, which is a very recent law that enables a leniency recipient to, in addition to cooperating with the government, to fully cooperate with civil plaintiffs' counsel. And if they fully cooperate in those civil cases, there's the theoretical ability to avoid what we call joint and several damage liability in the U.S. and instead have your civil damages based solely on your sales as an individual firm. There's also the ability to avoid the automatic trebling of antitrust damages, which comes after a verdict. The reason that I say that this is not always invoked is that there's been a lot of dispute in cases as to what level of cooperation you really need to provide to civil counsel, civil plaintiffs' counsel, and in many cases what they would want tends to be very onerous, and the benefit that you get in these cases under Ac Para would not kick in until there's ultimately a damages verdict, at which point you would get out of the joint and several liability and the treble damages. And as a practical matter, the vast majority of the civil cases are going to settle well before that. It's very unlikely that you're going to be in a position of having committed a criminal violation, having cooperated with the civil plaintiffs, and yet taken it all the way to a jury verdict to trigger the statute. And so it may well be that there's some significant settlement leverage you can get with plaintiffs' counsel because of the existence of this provision, but how it plays out in a particular case, it really tends to be idiosyncratic and fact-specific. But in any event, that's the catalog of benefits from participating in the leniency amnesty program. But there is a potential downside. The most significant potential downside is that once you go this route, you've basically given up the hope of a complete pass on the conduct through non-detection. There is an inherent instability, especially for the hardcore cartels, because of the existence of the leniency program. But it's always possible that things could happen that nobody's ever going to find out about. And had you not gone this route, you would have completely gotten away with it. That's something that needs to enter into the calculus. I think that's more relevant in a situation where you would stumble on the conduct as opposed to a situation where you receive some kind of a notification that there's a government investigation and you subpoena or a raid, and then you were to find out about the conduct. I think in that circumstance, the possibility of complete non-detection was not really material, and so you're probably not giving up very much. The other key cost is the civil litigation, which becomes virtually inevitable once there is any plea agreement that results from a government investigation. And if you're going to be applying for leniency, you can be sure that the government is going to be seeking to prosecute and get plea agreements from others. And finally, the leniency does not extend to conduct that postdates the leniency application, so that if there's any evidence of further obstruction of justice or improper conduct that postdates the application, you're not going to get immunity for that. That is the quick summary of the U.S. situation, and I'd like to turn it over now to Niels to give you basically a parallel presentation out of Europe.
Thank you, Frank. My name is Niels Erspel. I'm based in Arnold and Porter's Brussels office. I will speak about the EU leniency system, and I'll go through a similar structure as Frank, talking briefly about the rules and the enforcement record, and then turn to the leniency process, the requirements you have to meet in order to obtain leniency or immunity, to illustrate for you some of the complexities that are involved in that process, which are things you need to think about when you're weighing whether to go in or not. And then I'll sum up at the end with some remarks on what these pros and cons, in our experience, how you weigh those one against the other. The cartel prohibition in EU law is in Article 101 of the treaty. It's enforced by the European Commission, or the EC, and in substance, it really is very similar to the US provisions that Frank spoke about. It covers the same type of behavior, essentially, price fixing, bid rigging, market, and customer allocation. What is important, though, is that the EC in its practice, and it's been confirmed in this by the courts in the EU, applies a relatively broad interpretation to some of these terms. In particular, price fixing and market sharing and customer allocation isn't necessarily limited to what would be sort of what you think about normally as a multilateral scheme in which competitors agree on these things. There's been a slew of cases recently in which bilateral schemes, really limited to information exchange, have been found to constitute cartels. If you do get involved in cartel behavior, the infringement comes potentially at a very high cost. The EU can impose fines of up to 10% of revenue calculated at group level, and the calculation method, just very briefly, gives you a sense of why you get to high fines. The EU will base itself on sales, the relevant sales in the last business year, and take a percentage of that, typically 15 to 25%, and then it will multiply that by the number of years in which the cartel has been in existence, and then add again to that amounts for deterrence. So say you've been involved in a cartel in a major product, you can take your EU revenue for that, 15 to 25% of it, multiply it by, say, 5 years, if that's the duration of the cartel, and then add some on top. And I'll come back to the level of fines in a minute. One difference, though, is compared to the US, the EU doesn't have criminal powers. That doesn't mean that criminal sanctions are not a risk if you engage in cartel behavior in the EU. It is, insofar as several of the member states do have criminal powers, and they can apply those in parallel to the EC procedure. And it does happen. There are not many cases, but the OFT, for example, in the marine hose cartel, did impose prison sanctions. And we know from experience, and I think the OFT has made statements to this effect, they're actively looking for cases. Next slide. On just very quickly some stats. This slide here illustrates the number of cases the Commission decides per year, 5 to 6 cases a year. but also the number of cases it initiates every year, and we've taken the ones that are still pending. What is noteworthy is that in 2012, there's a significant jump, 11 cases, that's higher than it's ever been before, and is probably indicative of an increased focus from the EC on this. This slide, very briefly, shows two things. It shows the aggregate amount of fines imposed by the EU per year, which, like the US, is high. It's in the billions. And then it shows the average amount of fines per company in any given case. That, if you sort of take away the dip in 2009, places the average around 60 million euro per company, which in and of itself is high, but it betrays the volume or the level of fines which the EC does impose in some cases, which can be significantly higher. There are many cases with fines above 100 million, and the record still is held by Saint-Gobain for its role in the car glass cartel, where it was fined 880 million euro. And the runner-up is from last year, Philips, in the TV and monitor tubes cartel with 705 million. So I think these are higher even than in the US. Next slide. Turning to the leniency policy in the EU, this is set out in the EC's 2006 leniency notice. What this provides is that companies that have been involved in illegal cartels that affect trade in the EU can significantly reduce that exposure they have to fines if they agree to cooperate with the EC. The first company that comes in will, and to satisfy the formal conditions under the notice, will be granted full immunity, so no fine. While companies that come in later, number 2, number 3, etc., may get a significant reduction of the fines. And I'll come back to that in just a minute. What these benefits mean is that the leniency note or system really has become the cornerstone in EC cartel enforcement. It's a powerful tool in encouraging companies to come forward with insider information to the Commission. And the Commission has published a study recently which does show that the large majority of cases it brings are on the basis of leniency applications. That doesn't mean you should feel safe if you think you can trust your competitors in a cartel. The Commission also has made it a clear policy that it will, in addition to leniency applications, initiate cases of its own initiative. And it can do that on many bases, things it observes in the market. One thing we have seen, for example, happen is the Commission comes across information in a merger control investigation, and that leads it to open a cartel investigation. And that's just very quickly illustrated on the slide here. 77% of cases in the last 7 years are based on leniency applications. The lighter shaded part of the graph are cases initiated by the Commission itself. Turning then to the leniency scheme and looking first at the conditions for obtaining immunity. So the position available to the first to come in and the process you have to go through in order to get there. To obtain immunity, the first company to cooperate, in essence, has to provide the EC with enough information for it to carry out what it calls a targeted inspection. That's a dawn raid. If that's too late and the inspection has taken place already, for example, in one of the cases where the EC starts the inspection or investigation itself, you still have a shot at immunity, provided nobody else, of course, is before you. But in that case, you need to provide sufficient information or evidence to the EC to prove its case, basically. So in practice, it really is the first test, i.e., can you come first in and give enough information that the Commission can carry out a dawn raid that leads companies to obtain immunity. What does the cooperation then consist in? Well, you need to basically confess fully to the EC. You come in with a corporate statement in which you describe the cartel and all the relevant facts around it. You have to submit all relevant documents, incriminating documents that you have. And you have to remain available to the EC throughout the investigation. You really become the EC's, as it calls it, I think, the privileged interlocutor. It can call on you for any question it has. It will issue requests for information to you. You have to respond. You may be asked to make witnesses available for interviews, etc. As a rule, and that's important, once you come in, you also have to seize participation in the cartel, and you have to do that immediately. There is an exception to that, and you can discuss this with the EC, which provides that if the EC wants to do inspections and it's concerned that you stepping out of the cartel basically will tip off the others and perhaps lead to evidence being destroyed, it can allow you to continue in the cartel on a covert basis if you want. That does happen in practice. We've seen it happen also, for example, where US investigations are being conducted in parallel and the DOJ and FBI want to do wiretaps or try and catch the companies in the act, say, in a meeting. There are a number of other formal conditions. You cannot have revealed to others your intention to seek immunity when you go in. That's important. The Commission has withdrawn immunity from a company which did exactly that. It told its competitors in the trade association meeting what it was doing. You cannot have coerced others to join or remain in the cartel. That's different from what Frank explained to be the situation in the US, where you cannot be the ringleader. That's okay in the EU. You can have been the ringleader and still benefit from immunity. But if you've coerced others, you're disqualified. I don't believe there's been any cases like that in practice, but it's important to remember, of course. And then finally, you must not have destroyed or falsified or concealed evidence. And as in the EU, your application really needs to be genuine. You can't sit on the fence and try to have it both ways, say, I did this, but I don't think it was all that bad. In terms of process, for the immunity applicant, a marker system is available in the EU, and that's often of significant benefit because once you do decide to go in, you may worry that others are having the same idea. And the threshold for immunity is relatively high, so you're going to want to put together a good file of all the evidence you need to submit to the EU. By applying for a marker, you buy some time. You reserve your place in the queue, and you get some time to bring all the evidence together and try to meet the threshold of enough evidence to trigger an investigation. If you read the leniency notice, it sounds relatively easy to get a marker. You need to describe the cartel, the participants, the markets concerned, the period. In practice, though, the threshold is high. It's our experience that the Commission will insist on having more than a general description of the cartel and a few documents and some names. It will want a relatively detailed description, several documents, details of where meetings have taken place, details of persons that have been involved. Really enough, if you can imagine, that when it goes and does the investigation, it understands what this is about. And that's at the marker stage already. It will want to see that you have these elements. You may not have to provide everything to it, but you have to satisfy the EC that you are going to be able to do this. Once you get the marker, you will be given a period, as I said, to bring everything in. Typically, that's about 3 weeks, so you're going to have to work hard. And during that period, you build on the evidence that you've given the Commission to satisfy that it has enough to carry out the inspection. If you do make good progress, you can get that period extended, and often it does become a longer running process. Once the EC then is satisfied that it has enough, you will convert the marker into a formal immunity application. And that is when the EC then thinks that it will go off and do its inspections. Next slide, please. For the second through the door, there's no market system. The system really is built to induce a race of sorts. What happens is that instead of getting immunity, you come in and you get slotted. You get slotted in bands that correspond to fine reductions. To get qualified for such a slot, you need to provide to the EC enough evidence or evidence which represents significant added value. Now, what that means is you need to add really to what the EC already knows. And that's a high test because when you come in as the second or third, the EC will know everything that the immunity applicant has told it, and it may also have evidence which it has picked up in inspections. Nonetheless, on paper, the situation seems relatively clear. You get slotted, and each slot corresponds to a fine reduction. The second in the door gets 30 to 50%. The third through the door gets 20 to 30%, and subsequent applicants can get up to 20%. In reality, though, it's less simple. The slotting depends not just on when you came in, it depends on when you met the threshold for significant added value. And it means that if you come in second and you give some evidence to the EC, but it doesn't really represent added value compared to what the EC had, and of course you don't know what that is, you will not get slotted as second rank. Moreover, once you do get slotted, you will want to continue producing as much and as good evidence as quickly as you can, because your effort in cooperating in that regard determines whether, for example, if you're second, you get 30%, 40%, or 50%. So there is an uncertainty built into the system for the second and third and subsequent through the door. Adding to that uncertainty, the EC has discretion in assessing your cooperation. It has some discretion in assessing whether you've added significant value. And in particular, it has discretion in assessing where it should slot you within a band. It means also that it does happen that companies do come in and they get a very low reduction within the band, or they get no reduction at all despite cooperating. And obviously, if that happens, it puts you in a position that is even worse than had you not cooperated. Finally, and contrary to what's the case for the immunity applicant, as the second and third, etc., through the door, you're not told up front whether you are have qualified or not. You will only be told that at the end of the process, basically when the EC issues its statement of objections. What does significant added value mean? It's a test really of quality and of timing, and the test really is whether, without the evidence that you brought to the Commission, could it have proved all the main aspects of the cartel and imposed fines. If it could, it is allowed, it is justified in not granting you any reduction. How does the Commission assess the evidence? Written contemporaneous evidence is more valuable than something that is created ex post facto. So witness statements, for example, that you come in with are not as valuable as contemporaneous documents. You want evidence that is directly incriminating and directly relevant to the facts. That could be handwritten notes of a cartel meeting, rather than, say, travel records which show that you went to a meeting and you can use them to establish a date of the meeting. Ideally, you'll want to submit evidence that relates to new facts and circumstances compared to what the EC knew. But there are circumstances in which the EC will need corroborating evidence also. For example, in the Dutch bitumen case, the immunity applicant had told the Commission about a number of meetings that it had attended, but it hadn't been very detailed in explanations, and the second through the door came in not with new information, but with evidence that corroborated those explanations about meetings and added detail to him. And so it got slotted as a second, it came in, and it got a 30% reduction. If you're lucky, you will be able to bring evidence that extends the duration of the cartel, and the Commission will then not take that into account in assessing the fine against you, which basically means you get partial immunity, partial in the sense that for a period of a cartel, the Commission will not impose a fine on you. And then to timing, timing really is as important as the quality. If you wait too long before going in because you want to constitute a good file, you risk being bypassed and somebody will jump the queue. And the longer you wait, the greater the risk also is that what you come in with really is the same as the EC knew already, and you risk just repeating facts. And timing is also an element in the overall assessment of the corporation once you're looking at should it be 30 or 50% within a band. Very briefly, in addition to thinking about, okay, can I qualify for immunity or leniency at EU level, something you need to think about when you are looking at cooperating in the EU is the fact that there are two levels of enforcement. There's the EU, which we've been speaking about so far, where the European Commission manages the policy, but then there are the member states that have broadly equivalent competition laws and leniency schemes, and that can enforce, in principle, in parallel with the EC. And you don't know until the EC starts an investigation whether it's going to be the EC or the member state. And that creates a number of issues. First, if you apply at the EC level, there is a risk until the Commission starts an investigation that the case can be referred to the member state. If you haven't then applied for leniency in front of the member state and somebody else has, you will lose your first place in the queue. Second, if you apply only at the EC level, you risk that an investigation is started at national level for criminal prosecution and you will not be protected. And third, there is a risk that there is a risk if you apply at national level that you've not applied at the right member state. You may think you've applied at say 2 or 3 member states in which the cartel really had an effect, but somebody else also applies in a third member state and you lose your first place in the queue there. There is a system to try and address this issue. The European Competition Authorities cooperate in what is known as the ECN, and within that they have put together a model leniency program that contains a so-called summary application form that allows you to apply at EC level and at the same time make summary applications at the national level, which functions as a marker. So you go in at the EC level, you do summary applications at national levels. Should the EC not take the case and revert them to the national authorities instead, your place will be reserved. That system was reformed last year, and I won't speak much about that now, but just say that one significant innovation in that reform was that where previously this marker system in the form of summary applications was available only to the immunity applicant, it now also is available to the second and third applicants that come in and apply for reduction in fines. Summing up and looking at what this means, there are, as seen, some very significant benefits to cooperating, potentially at least. For the first to come in, the situation is particularly clear, both in terms of process and result obtained. Even though the threshold is high, you will know early on whether you've qualified. And once you do that, you really run relatively little risk. For the second and third through the door, and to some extent the third, the potential benefit is significant also insofar as you can get a significant reduction in the fine. You also have the opportunity to be the first to come in and extend the duration of the cartel, and you may be able to get partial immunity. It's also clear that a company's decision to cooperate doesn't come without cost, however, just as in the US. As discussed, first of all, the threshold to qualify is high, and it's a burdensome and highly disruptive process to go through. And there is an inherent risk, in particular for the second and third and later applicants, of coming in, cooperating, and yet not getting any benefit out of it. And you don't know until the end of the investigation what situation you're in. I don't want to overstate this, but it's an important fact. And if I can just, for 1 minute, go to the next slide to show you some statistics. This illustrates the extent to which applicants are successful, and about 19% of leniency applicants are not successful. So it is a real risk. And in terms of how significant the reduction you obtain is, it's by far not all companies that will get the maximum reduction. For example, in the second band, the average is about a 43% reduction rather than 50%. So going back to the disadvantages, if you want, or the costs and limitations in considering whether you should do this. Cooperation also entails, for all practical purposes at least, an admission of guilt, and that may impact subsequent litigation by private plaintiffs, and there also are potential discovery issues involved, which we'll deal with in one of our later webinars. And there are issues such as reputational costs and potentially also a risk that competitors may retaliate. Overall, however, it is our experience that for the immunity applicant at least, the costs really are outweighed by the benefits. And I think that's all the more so given the high risk of detection today with highly efficient leniency systems in place in many countries, as Frank noted. For the second and later applicants, the assessment is much more fact-specific. You really want to understand fairly quickly how strong a case, how strong a file you're going to be able to put together, and how quickly you can do that, and try and weigh, if you can, that against what you think the EC already knows. You may have received a request for information, you may have been subject to an inspection, and that may give you some guidance as to what it is the EC knows already. And you may have a good sense of how many documents you have, or really is it only witness statements you're going to be able to come in with. And those type of considerations will then drive you. If you think you have a good file, typically, at least if you can do that quickly, there are significant benefits associated. Frank, I think I'll stop there, and then maybe we spend 2 minutes on some multi-jurisdictional considerations.
Sure. Thanks, Niels. Basically, to sum all of this up, it's a complex landscape. A lot of the issues is between the U.S. and the EC are very similar directionally, but in a lot of cases there are distinctions that may well be relevant. And so I think our bottom line message is that in any situation implicating either international commerce or international conduct, there's really an imperative for counsel with the client to get a handle as quickly as possible on the global situation, on what conducts occurred around the world and what the commercial flows are internationally, to then map out a strategy for how to move forward. In particular, you want to be thinking about what jurisdictions you want to be reaching out to determine the availability of leniency and to secure markers. you want to be thinking about the different timelines and processes that are available under the different regimes to make sure that the jurisdictions that really should be out front in a particular circumstance, given maybe the nexus of the commerce or the nexus of the conduct, are the ones who are really driving the process, as opposed to having some secondary jurisdiction because of their accelerated process be the one to really drive you to your investigation and your disclosures, which in turn then could have a ripple effect or a backdoor effect in a way that wasn't intended. And so I think every case is different, and this is all a very complicated set of issues. But putting out those global issues as early as you can and thinking about it in an integrated way is incredibly important.
I think, Frank, another point to consider is that there may well be some tension between, on the one hand, you wanting to cooperate in one jurisdiction. You're going to do whatever you can to meet the threshold and submit significant evidence, and you will want to go along and give explanations of this evidence. And the flip side of that, which really is that you end up making admissions which risk locking you down in another jurisdiction and potentially increase your exposure. You need to think about these sensitivities in a global context, and I think it's critical for counsel working with the company in each jurisdiction to be really attuned to the risk that what is said in one jurisdiction may negatively impact the company's position in another jurisdiction.
Yeah, and on that same theme, I think it's very important to understand globally how the different investigative processes are likely to play out. There's a distinction between some jurisdictions, such as the U.S., that are going to want to hear directly from witnesses to corroborate what's in attorney proffers, versus jurisdictions that tend to rely simply on the attorney proffers. At what stage do documents need to be gathered up and produced, including documents potentially from outside of the enforcement power of the jurisdiction on a more voluntary basis. And again, working through all of that in an integrated way is essential, because there's a real prospect for a backdoor flow that if you inadvertently provide one enforcement agency with documents or testimony that you could have kept meaningfully out of another jurisdiction, your chances of keeping it out at that point are dramatically reduced. And hopefully you want to have thought all that through in advance, as with the knowledge that doing it in one place is likely to open it up everywhere else. So I think it all goes back to the same theme of of an integrated global strategy being essential, particularly given the fact that these agencies are it's a complicated subject to what extent they can share specific information during the course of the investigation. That would be a whole other webinar. But the point is, they do talk to each other, and so you have to be consistent and cognizant of that.
All right, I think that's it. Do we have questions, Frank? We want to pick up.
If anyone has a question, please send it to us if you can now. If not, certainly feel free to contact any of us. There was one question I received privately, so I don't know if I want to identify who sent it. And basically what it asks is, do the compliance elements that are in Chapter 8 of the U.S. Sentencing Guidelines relating to monitoring programs, training and education compliance. Are they, as I understand the question, are they relevant to the leniency grant of the leniency decision? And in our experience, I think the answer to that is no, not directly, in the sense that if you can come in with evidence of the violation, and you can assure the government that the conduct is terminated and won't be an issue going forward, that would be essentially the leniency criteria. Those other issues about a compliance program and training and all sorts of things relating to the ongoing good behavior compliance type work is very relevant, though, in the context of ultimately, if you don't have the amnesty slot and you need to enter into a plea agreement and pay a fine, then those considerations do come in under the sentencing guidelines and may well be relevant. And so in terms of the role of a compliance program and an in-house compliance department, the two benefits to having a robust program are in the unlikely event that something does happen and you need to actually deal with the sentencing guidelines formulas for a plea, you're better situated. But more importantly, it's to keep yourself out of trouble in the first place. These programs tend to be very effective in instilling an antitrust sensitivity in the appropriate personnel at the company, be it salespeople or division executives. And that's the real benefit, is the prevention of the problem in the first place. I hope that response has been useful to the gentleman who sent me the question, but we're certainly happy to chat offline, call any of us, email any of us, and happy to chat with any of you further. Enforcement of criminal antitrust violations. The Federal Trade Commission, which many of you may be familiar with, does not get involved in criminal matters and criminal prosecutions. The only types of conduct that tend to be prosecuted criminally in the United States are what we consider to be hardcore violations, meaning price fixing, bid rigging, or express market or customer allocations at a horizontal level between competitors, where there is typically no legitimate business reason for the companies to be working together and talking about the relevant issue. Things that are more related to distribution issues, vertical customer supplier issues, are not really in the criminal realm in the United States. Criminal violations have very serious consequences in the U.S. At the company level, fines are very significant. The statutory maximum is $100 million per violation, but even that is not a hard limit. There's an alternative provision that's referred to as the double the gain or loss provision, which enables the government to bypass the statutory limit of $100 million and seek an amount that is double the harm inflicted by the conspiracy or the gain to the conspirators. And the government's, although this has not been tested in litigation, the government's position at least is that double the gain or loss provision applies to the conspiracy as a $6 billion. And you'll see on the right of the chart a ramp up in the average incarceration period for antitrust offenses. What we're here to talk about today is the DOJ's leniency program. And that program really is the centerpiece of the DOJ's criminal enforcement effort in the antitrust area. There has been a corporate leniency program in existence in the U.S. since 1978, but it did not really become an effective tool until it underwent some significant revisions in 1993. Under the older program, the division received an average of 1 application per year. Today, the application rate is roughly 2 per month. Roughly 90% of the fines that have been achieved by the government since 1996 are traced to investigations that have been advanced by a leniency applicant. And roughly half of the current investigations that the DOJ has are related to a leniency applicant. And so that distinction between the 90% and the 50%, I think, is significant because it shows you that the largest, most high-profile, most volume-intense matters really do tend to be driven in large part by the leniency program. Various and numerous other jurisdictions globally have adopted leniency programs based on whole, and is not limited to the gain or the harm relating to one particular defendant's sales. So if you were to take a conspiracy-wide view of the harm or the gain and then double it, the numbers can get very big very quickly. And for that reason, we do see fines very substantially in excess of $100 million. The two largest in history have both been $500 million. One for Roche in 1999 relating to the vitamins cartel, which was a plea agreement to settle, to resolve the matter for $500 million, and one very recently for AU Optronics that was actually the result of a trial conviction and a judicially imposed sentence of $500 million. At the individual level, there are very significant potential prison sentences, averaging these days about 24 months, theoretical maximum of 10 years, although I don't think anyone envisions it getting that high for antitrust-related offenses only. There's also the prospect of individual fines. So some quick statistics for folks to see. Before 1994, the largest corporate fine ever imposed for a Sherman Act violation was $6 million. Since then, there have been approximately 100 fines of $10 million or more and 21 fines of $100 million or more. And you'll see on the left is a chart that shows you over the last 10 fiscal years the aggregate amount of the fines, totaling somewhere around the success of the U.S. program in generating enforceable prosecutions. They're not all paralleled. They're not all the same in terms of the mechanics, but the concept of leniency for the first to report is spreading globally at a rapid rate. The destabilizing effect of the cartels, the destabilizing effect of the amnesty program on cartels is the key driver. And that has been a tremendously successful component of the program. In terms of the benefits, in terms of the ground rules for the program, what you can get is full criminal leniency for both the company that cooperates as well as present and former employees. What you need to do is be the first company to report in a particular conspiracy. If you are not the first to report, then amnesty is not available. There is the ability to receive substantial cooperation discounts for subsequent cooperation in the United States, and the order of your cooperation in terms of the lineup of the conspirators does matter. But beyond position number one, it's a question of a discount off of the eventual plea agreement fine. Only the first in qualifies.
And now I'd like to hand the call over to Frank Liz. Over to you, Frank.
Thank you. Good afternoon, everybody, and thanks very much for joining our webinar. This is the first in a series of three that we're going to be doing. Our topic today is amnesty and leniency in the United States and in Europe, the process for securing it, what it means in each of the jurisdictions, and some strategic issues that arise in that process. We will have another session that has not yet been precisely scheduled sometime in April to talk about the process for responding to search warrants and dawn raids and all of the issues associated with that. And then in May, we will have a final session on the actual conduct of cartel investigations on both sides in terms of dealing with the agencies on the substance of the investigation and resolution strategies for cartel investigations. So to get started, I'm going to kick it off with a discussion of leniency and amnesty issues in the United States. And then I'll turn it over to my colleague Niels Ersbol in Brussels to talk about Europe. And then we'll come together a little bit at the very end to talk about some multi-jurisdictional considerations and issues that tend to arise in these cases. So in the United States, the U.S. Department of Justice antitrust jurisdiction has the exclusive responsibility at the federal level for